Some of the responses to the last video indicates to me that you may need to have a quick refresher video on court procedures. And my guess is the way the Commonwealth has gone about this and made the defence have to battle for every single little detail has probably given you the misconception that every single move either side makes has to be put into a motion. That's not standard court procedure. Generally, you would only bother the court to compel something or another if one side or the other is not cooperating. That's when you usually see these types of motions. Usually, the lawyers will bicker amongst themselves until they come to some sort of agreement as to how they can reciprocate discovery amicably or allow access and so on. And so, from trial 1, we saw that the defence did have access to 34 Fairview Road because it's no longer in the possession of the Alberts. We saw footage of the basement, the back of the house, the side gate, and so on. It was never put into a motion to have the court compel the owners of 34 Fairview to allow the defence to have access because the owners of 34 Fairview allowed them to have access without argument. The same applies to the roadway and the sidewalk at 34 Fairview Road. Those are public access, and nobody has any right to prevent the defence from inspecting public access. And that is why we don't see any motions for 34 Fairview Road or the public area out the front of 34 Fairview Road for the defence to go and investigate themselves. The reason we see a motion for One Meadows is because the O'Keefe family have refused to give the defence access to One Meadows and John's Traverse. Additionally, the Commonwealth has refused to give the defence access to the Lexus. This is enshrined in both the US Constitution and the Massachusetts Constitution under due process and a right to a fair trial. The 5th and 14th Amendments to the US Constitution, along with Article 12 of the Massachusetts Declaration of Rights, ensure a defendant's right to present a complete defence. If access to a crime scene or relevant property is necessary for that defence, restrictions on access could be challenged as violating due process. The compulsory process clause of the 6th Amendment and Article 12 of the Massachusetts Declaration of Rights provide the right to compel the production of evidence, which may include accessing a location for investigation if it holds exculpatory evidence. I'm sure you're all familiar with by now Brady v. Maryland and discovery obligations. The Brady Doctrine requires the prosecution to disclose exculpatory evidence, including access to property if it contains evidence favourable to the defence. In Massachusetts, Rule 14 of the Massachusetts Rules of Criminal Procedure governs discovery and may support defence motions for access if the prosecution controls or has access to the property. Under the public or constructive access doctrine, if the property is publicly accessible, such as a street, sidewalk, or government-owned location, the defence may have an implied right to investigate there. If law enforcement had lawful access to private property for investigation, the defence may argue for equal access under due process principles. This is generally executed under a motion like the ones that we saw for One Meadows and other access to videos, etc., in which the courts must balance property rights with the defendant's constitutional right to a fair trial. Outside of all of that, consent and private agreements are generally the way that these things are resolved. If the property is privately owned, the defence may seek voluntary consent from the owner, which it appears they have done with 34 Fairview Road. If the prosecution has previously secured access, the defence may argue for reciprocal access under fairness principles. As we've seen over and over again in this particular case, the prosecution has absolutely no qualms about violating due process rights. They well know the substance and effect of all of these doctrines, yet they continue to violate them and force the defence to have to put motions to the judge. And as frustrating as that may seem, that they just can't follow the law and do the right thing, It does have a benefit to the defence. It means that every single obstacle that the Commonwealth puts in front of the defendant and every single court ruling that the court has to make is now on record. It's now preserved for appeal. I would love for an appellate lawyer to sit down and work out the entire list of possible errors the judge has made to date, because I'm guessing it's pretty damn long by now. That isn't to suggest that the appellate courts would agree with every single point. You only need one to either overturn conviction or be granted a new trial. Nonetheless, that is the point of making motions where your lawyers can't agree with each other and then preserving those motions on record. The number of motions between one case to the next can vary wildly, depending on the amicability of the lawyers involved. But in this case, we have some rare insights into how that amicability has fallen apart. Aside of the fact that the evidence simply points to John being harmed some other way, we also have the behaviour of the prosecution's witnesses in Aidan Carney's case, where they tried to use him as a nexus to connect Karen Reid to witness intimidation. And on top of that, we also have the Sandra Birchmore case, which ties together a common pattern, or MO if you prefer, providing us with a glimpse of how these people get away with murder. And part of that MO involves complete and utter disregard for the doctrines that we just discussed. So, in essence, just because there's multitudes of motions doesn't mean that this is normal court process. The defence does not need to file a motion for every single move that they're going to make, particularly when they already have access and they already have permission to do things where they don't need the court to compel it. In fact, if they were to be filing motions for things they already had access to and could already do without the court compelling it, it would be deemed frivolous. And Auntie Bev would be the first one to jump up and down about wasting her time. If I were a betting person, I would say that there's a strategy that the Dream Team has dreamt up that may involve using the Commonwealth's stubbornness in Karen Reid's favour. Now, I could hazard a guess at what that strategy might be, but I don't want to keep giving away hints to the prosecution. Let's just say I played a very similar strategy in saving my channel from being struck just recently. You want your adversaries to think that you're going in a certain direction when actually you're going in a completely different direction. And that is why the Commonwealth keeps forcing Karen into these situations where she has to lodge motion after motion, because they want to know what their strategy is. I know it's hard for us to sit back as onlookers and wait to see what happens. We're scrambling for every tiny hint that comes from a motion as to what might be going to happen. But the more we refer to these motions to direct us in what might be going to happen, the more we're falling into the Commonwealth's trap of assuming where things are going just given the motions. You're just going to have to trust me when I say, hang in there, because 2.0 is going to be a wild ride. Lots of surprises, lots of things we didn't know about, lots of strategy that might just trip the Commonwealth up. But best of all, we're going to have visuals. That much I think we can guarantee.